Hello, it's Philip Taylor speaking from Richmond Green Chambers, and I'm looking at an important book here, The Law of Habeas Corpus. It's this book here, published by Oxford University Press, about 250 pages, now in a third edition. The authors are Judith Farbey, Queen's Counsel, just appointed Queen's Counsel this year, 2011, the Honourable Mr. Justice R.J. Sharpe, and Simon Atrill. The book is actually started off life as a thesis. It starts off with the historical aspects of habeas corpus and runs all the way through with its theme. There's a very important index at the back, and it's written in the standard structure that you'd expect for this type of work, proper prose, and you've got footnotes there to justify the assertions and the relevant links that we're looking for. There is a note right at the beginning on the new edition from Doughty Street Chambers, and what I'd like to do is say I think this is an important book for me as a practitioner, certainly in trying to identify what we understand by habeas corpus today, and also for anybody involved in jurisprudence and legal philosophy about where we stand as citizens and as people when it comes to rights and the state and taking away and depriving people their liberty. The title we've given this review is Habeas Corpus, the Evolution and Vulnerability of a Fundamental Right. And what we say is this: the cornerstone of our liberties, habeas corpus, is actually an ancient writ, the origins of which are described in this excellent book, aimed at those who are either new to the subject or experienced in these matters. And it's a legacy really of the Middle Ages, where habeas corpus became more firmly entrenched about 4 centuries ago as a means of protecting the individual against unfair imprisonment, confinement or detention. And I would hasten to add how many of us have had the problem of trying to find our client when he's been moved from one prison to another. And therefore it's important to keep an eye on where your client is and where people are at any given time, because there's frankly a notorious laxness in certain areas as to where people might have actually been put. And it's something that really must be addressed because it's such a fundamental right to take away someone's liberty. Worryingly, it's taken something of a battering fairly recently, this area of law, because of the controversies surrounding the war on terrorism, for example detention without trial, and the imprisonment of detainees at Guantanamo, which I notice is still going on in 2011, even though the current president in the US said he was going to do something about it. So this book is timely, dealing with those topical issues, but not before offering up a thorough and useful examination of, as promised by the title, the law of habeas corpus itself. First, there's an introduction to the history of habeas corpus, tracing its development primarily from the 17th century origins. So between the 16th and 17th century, there was the writ of habeas corpus, which took its modern form, gaining its conspicuous place as a fundamental ingredient in the UK's constitution, and that must have an effect internationally. The significance of habeas corpus in the modern context is that it empowers the court to secure the release of individuals from unlawful custody over a range of circumstances, from detention in prison to the custody of a child, to patients detained for compulsory medical treatment, and, as in a number of currently high-profile cases, individuals wrongly held in detention as a result of the war on terrorism. And that really is why this is in the new edition and why it's still very current news. So fundamental a liberty is habeas corpus that all too many take it for granted, which offers all the more reason why it should be jealously guarded by those charged with ensuring its preservation. Interestingly, this important book started life as a thesis, as I've indicated, and you can see from the detailed footnotes, just take one there, that there is a huge amount of work that's been put into this, and I really do thank the authors, because they have endeavoured to maintain the structure and organisation of previous editions whilst examining all the recent developments that we have, especially with the Human Rights Act. We were amused to read a quote in the Times Letters column some time ago from a certain Mr. Benjamin Franklin, who remarked in effect that those who would sacrifice freedom for safety deserve neither freedom nor safety, and that's something we might consider. Anyone who's concerned, especially in a professional capacity, with issues raised by this 250-page book, should read it in some detail in our view. It's meticulously footnoted, as I've indicated, throughout, and there are some useful tables of cases, legislation and so on, as well as treaties and conventions on both sides of the Atlantic, and there's a great index. It points the way, in our view, to literally hundreds of avenues for further research on the evolution and vulnerability of our fundamental right. It's not going to go away, but this book should be retained by you because I think it's excellent. Thank you very much. Bye-bye.